Oh, I think I'm live. Hey guys, it's been a while. There is like so much happening right now. All these Kohberger docs have dropped. Like I'm trying to see if I don't know, my internet is so slow. Oh my god, hello Diane! Welcome, it's so good to see you. Yeah. I can't believe all of these docs that just dropped all at once. There's like so much to talk about. And then, oh my gosh, what did you think of that dollhouse? Mercy Cat, welcome. Mercy Cat and Diane, did you guys see the dollhouse? I know I had a chance to send it to Diane. I can't handle it like that. It's just like, what are people doing in their spare time? They're making houses. I don't even know where that came from, but I do think it's really funny. Yeah, let me see if I can pull it up. I'm talking about it. I see. Wait. I think I have it on the YouTube. All right. Can we see this tab? Yeah, look at me. Here's my channel. Oh. Oh, I see, Diane. I'm so sorry, I forgot. I sent it to you and then... All right, where did I go? Okay, here it is. Can you guys see it? Oh my gosh. Let me see if I can make it bigger. I mean, if you can't laugh, right? No, I think that's as big as it's gonna go. So it looks like it's on this table. I don't know what that is. Oh, I wish I could zoom in. I don't know why the top floor up here is green. Oh, Suzanne, welcome. I'm so happy you're here. I'm so happy, Mercy Cat, Diane, everybody watching and replay crew. Thank you for being here. I just thought there's so much going on today that I need to just get on and see how it goes. This is so funny. I don't even know. What does it say? 1122 King Road, Moscow, Idaho. Oh, there's measurements. 35, 43, 52. Oh, look. Like, I know, I've seen these tables. I mean, we've all seen these weird tables that just fold. This is so detailed. Oh, thank you, Diane. Oh, Truth and Justice. True Crime with Anna. Welcome, Anna. Hello, Jeff H. Yeah, what do you guys think of this dollhouse? I just can't get over it. Oh. And then, gosh, I can't believe that the court page, we're all the way up to 2025. It's been so long. I'm especially interested in this neuropsychological psychiatric evidence because Anna, you sent me something earlier where It's not allowed in Idaho to put someone to death that has a disorder. Which that makes complete sense. I don't know why anybody would want to put to death someone who has a disorder. We call it maquet. Well, how do you pronounce that, Diane? Yeah, so much for privacy. So I wonder if they use that in their SNP. Because I do believe that these disorders, they are features. You can probably see that there's a pattern. Now, law enforcement may say, oh, well, we don't really know what we're looking at. But I don't know. If they see patterns and they connect to those patterns, not realizing that it is medical information, they're still looking at it, and there's definitely going to be a difference between if you're looking at a SNP and there are features for cancer, features for autism, features for diabetes, any of these things, there's definitely a pattern. Oh, Twiz, welcome. Okay, so Mercy Cat says there's several biomarkers correlated with ASD. Thank you for pointing that out. Okay, Suzanne B says, if I'm correct, Idaho doesn't allow for an insanity plea. Yeah, I don't think that that's where they're going, but yeah, I don't think so either. Oh, right, because Lori Vallow, because she couldn't do it. Yes, you're so right, Suzanne B. Because Lori Vallow went through all that. Hello, Kelly. Amethyst Noir, welcome. Love you. It's not about insanity plea. That's what Twiz says. Yeah. I mean, I remember Lori Vallow going through all those evaluations, but she definitely, there's just there's no avenue for the insanity plea. But I think the argument is going to be used differently here. It'll be used as actually, Anne is attacking it from many angles. She wants the death penalty stricken, which, of course, obviously, we all want that. Meg P, welcome. So she has, I think, didn't I see something here about how she wanted, it was on the back page. She wanted this death penalty stricken for sanction reasons. And then also this other reason for the autism. So there's two angles there that are going after the death penalty. The case is over, Twiz. Oh, please tell us more about that. I would like to hear. Meg P! Aw, good to see you. I don't know if I said hi to you yet. I got Kelly and Amethyst. Amethyst says it's a medical genetic abnormalities, which is in the Eighth Amendment. Oh, very good. Twiz says all the state has is transferred skin cells. Right. Oh, Meg, I like your little hearts. They have little moving lines. They're going back and forth. Yeah, okay, so Suzanne B says she called autism right from the start. And she's more convinced as to Asperger's rather than autism. Yeah, I think many people had a gut feeling about that. But that's awesome that you called it. You knew right away. I mean, that's great. Ro, welcome. Twiz has been malfunctioning? How? I love you, Amethyst. So this is going to be interesting that she's coming at it from two different angles, so I'm sure there's another one in there somehow. I'm particularly interested, as you know, in the DNA in this case. Moonvale, welcome. And I am just highly disappointed that there were blood DNA samples found at the scene. Normally in the real world, we aren't talking about Idaho here, they're kind of in their own atmosphere. Blood DNA evidence would take precedent. That is the route that you would go. And I know that there are, I guess you could call them rumors, that maybe one of those is JD's. And wasn't there a rumor where they were looking at JD for a while? They had him in interviews for a long time before they ruled him out. I would be interested to know if that other rumor that JD has a white Hyundai Elantra, if that's true as well. But anyway, you would definitely want to go the route of the blood DNA evidence. Regardless, because we don't even know what the weapon was. Kathy! Kathy Indie Zone, welcome. There's so much activity on the docket. Meg P says, they said ADHD and autism are related. I believe it. Yeah. Oh, Truth and Justice with Anna says she feels the state wants everything taken out that could give BK a good defense, but that wouldn't be fair. I would agree with that. Wendy, welcome. Oh, well, here we are. We got a live going, and it's so great that this is your first live. Kizan, didn't I talk to you earlier? I thought I talked to somebody on the comments. Kizan says, how likely is it that they were able to collect trace DNA from a smooth surface button snap without any of the same DNA being present on a serrated surface like leather? You bring up a good point. I don't think I thought of that before, because DNA sticks to fabric a lot better. DNA has a lot of difficulty sticking to smooth surfaces, especially metal. And then, there's that whole brass thing where the molecular components of brass are DNA killers. And it also cuts back, it's antibacterial too. So whatever mechanism that is, that it's antibacterial, it's killing those germs, the DNA, the skin cells, and it's removing all of that. So not only is it the smooth surface it won't stick to, you've got all those other molecular things going on. And so, yeah, I think you're right. It should have been on the fabric. It should have stuck to the fabric more than the metal. So that's backwards. Great question, Kazan. Thank you. Okay, Suzanne B says, his emotions or lack thereof. Oh, I can put you up here. Here you are. Wow. Okay, so Suzanne B says her husband's BFF has Asperger's, and he is the director of the blood DNA lab in the community hospital network in Indianapolis. And he's very similar to Bryan. Yeah, see, it's amazing. They are like superheroes, or they're super smart in one area or multiple. It's kind of amazing. Yeah, I have someone close to me who probably has that, but when they were alive, I don't think autism or ADHD were a thing, but they are a genius in their field, and they help create their field. and that's known as information technology as we know it today. And they didn't have information technology courses. Eventually they did. He has 2 degrees, 2 in mathematics, because it wasn't there and he helped pioneer that field. So I don't know if Asperger's, if it's right to look at it as a disorder. Maybe it is, but they are so smart in some areas. They're just genius levels. Okay. Where did we go? I am so behind on your... So they dropped that one of these things, motions, because the state wants to use the 3D model of the crime scene, because obviously it's no longer there. But then look, it was leaked. Where did it go? Here it is. Oh no, it's over here. Here you go. The 3D model was leaked. I don't know how the state did it. I'm just kidding, guys. That's this is a dollhouse. Like, I don't know why this is going around right now. I think it's hilarious. But here it is. This is their 3D model. It's great, isn't it? Oh, and I know that there's these rumors out there that Bryan took his shower curtain because it was missing from his apartment. So he had to lay that down in his car so DNA didn't get in his car. Well, there would be fibers from that plastic sheet in the car if that were true. Because everything has fibers. I mean, our skin has fibers. It's slushing off everywhere, and so does that. So they didn't even say that they found plastic fibers or in the car. So I think that is just disinformation. And like, even if he is a criminology major, like, it's the wrong, the media is wrong, that's not, he's into like the technology side, the cloud computing, not the clean up the crime scene side. But like, even if he was, where do you think he learned, if he learned it? He would learn it from law enforcement. So law enforcement definitely knows what to look for, because they created those standards to be able to look for that kind of forensic evidence. So if it was in the car, they would have seen it, and they would have seen fibers from other things if he did try to mask what was ever in there. I know, they come up with the most ridiculous scenarios. And then here's the crime scene they made, the 3D model. McPhee, he's gonna wear it as a cape. Yeah, take that shower curtain home, Jeff. Okay, Amethyst Noir says shower curtains attract lint. Yes, and it also attracts mold. It attracts skin cells. Our skin cells are all over those gross shower curtains. There definitely would have been more body fluid in the car. Like, they didn't even say they found Bryan's sloshed off stuff. I don't know who said that, Diane. Did the news just make that up? Because so around Halloween, they were really pushing the Michael Myers outfit. Or was it Jason? Of course the news has to do that during Halloween, even though that's not even a thing. It's not even a thing. It's not even a part of the evidence. Maybe he used a K-bar to hammer the shower curtain in so it wouldn't move. Look at this. Okay, so you guys, remember, I can't get any of my older work on Twitter. I have all of these articles, and I know I've mentioned this before, but from the state's own words in their motion for protective order, it says the ISP lab didn't find an STR on the snap until, what was it, November 22nd? It was like 7 days later. So where was the sheath all that time? And how in the world is there still skin cells on a surface that kills them 7 days later? Like that's really weird. What else do we have here? Connie Lewis, welcome. She says she changed her shower curtain every 4 months because of the bacteria that get on them. But that's just me. Right? And, if there was blood from the victims, it would be all mixed up with the bacteria, with the mold, all the other stuff. They would be able to see that mixture. Tom Campbell says, why would you bring a used shower curtain? Doesn't make sense, right? You would at least go get better plastic at Lowe's. Why you gotta take your own shower curtain? This is it. Let's see. Kathy, right? Kathy says the best is he wore the black Dickies outfit from Walmart to repel DNA. Like a Dickies suit is kryptonite to DNA, right? Yeah, it just kind of repels off. Toga. Susan B, you going to a toga party? Oh, Wendy says the red DNA would slip right off that shower curtain. Yeah. Yeah, it would be very hard to control it. Especially since the shower curtain would be like very odd shape. And you can't control those minute fibers or minute genetic material when you're using a very odd shaped shower curtain. I mean, you should have got it better ones at Lowe's. Tara, welcome. Tara says she just washes hers. It comes up like new. Twist says maybe he put fabric from his Dickies inside the snap to preserve the DNA, then wrapped it around the shower curtain. Yeah, I think that makes the most sense. That's definitely what he did. Glass doors are gross. Yes, they are so hard to keep clean. Diane, what would you like to share on X? Anything you want to share, I'll put it up. Okay, so Amethyst says, I can put this up here. Not what I read, as well as the only match to BK DNA is identified in the transcripts by the FBI with a footnote, no FBI report. Yeah, so do they even have, these experts that, or not well, some of them were experts, but the witnesses they had on the stand in that recently dropped transcript, they just made everything much more confusing. And it doesn't look like they documented anything. At one point, I think Othram called him over the phone and confirmed something. And I was listening to you, Kathy. I was listening to you read it. And I go, oh, that's it. That's right there. Like, there's not going to be a paper. That's not the only place, but that is a big glaring one. And so just, do they even have a record of this phone call? I doubt it. This says he clicked on stuff. Yeah. Oh, wait. On March 23rd and 22nd. Then extra fabric to line the button and preserved it all with a shower curtain. Yeah. David Bird, welcome. Yeah, David Bird says perhaps he threw out the curtain because it had mold on it, because it had lots of trace DNA on it of his own and whoever lived there before. All right. Can I share? Do you think it would be okay if I share one of Heather's posts? Do you think she'll mind? I think I reposted it. What is this? This came, okay, so I was just scrolling through, and a lot of times Heather's posts don't come through my feed, and then I don't know why today it did, and then I'm just like, what did you find here? Like, what is this? I mean, what? Like, oh, PFAX, you're on this one too. Oh, Ro, you bring up a good point here. The state doesn't want Bryan to provide his alibi or any cell phone information. That's really weird. Like, Danity Kane, welcome. Okay. So what does this say here? It's always winter and never Christmas. And that's not weird. Stickers on poles will burn down a bridge. Don't feed the trolls or the feds. That is kind of funny. So Bryan is a character in Barbie, A Perfect Christmas. He is voiced by Silence. Bryan is in a band, and he is Hitler's Court. And he is a Hitler's Court fan. Video blog. Story, Kill Kit, physical appearance, bushy eyebrows, personality, 1994 creeper rap star, fan of plastic gloves and birthin' hips. Quote, unknown due to his silence. Oh gosh. Oh, it's a movie, Barbie, A Perfect Christmas. The Sound of Silence. Oh. For his species, it says, and so. Occupation, stalker, and serial killer, and a band member. Okay. That is awesome. And then we have a picture of Bryan here. I can't believe this. This is so funny. Here's more of the story. I hope this is okay. All right. let's see, where was I? Barbie and her Santa, Riley, and Hushley meet Bryan and his band in the Poconos, PA after Santa overhears an IGG tip. Bryan is a big fan of serial killers video. He recognized death almost instantly. IGG Bryan informs Santa that the band doesn't have a lead singer, so they have no IGG or evidence to prove themselves, but he wants to be on the court's website badly. Hushley had written a song that she wanted to live stream. Riley performing in Pullman, but she and her sisters were unable to make it to Pullman due to snowstorms. Barbie suggests that they put on a concert with Santa, performing the song with Bryan's band instead and live stream it. Santa poses multiple false narratives, and they agree. Hushley tries to plan the concert by herself, but finds it stressful. Ooh, that's just like foreshadowing that she's trying to plan this out, this case. Anyway, Hushley wants to be independent because that's how she views Barbie. Barbie reassures Hushley that she always gets help planning big events and reminds her that Bryan was impressed by her false facts, which she made by herself. At the concert, Bryan and his band performed with Santa, and it is live streamed to Hitler's website. It gets a lot of views, and the audience gives them a standing ovation from Jeff H. and the Genius Guilters. Okay, physical appearance. Grad student with bushy eyebrows. Bryan, blue eyes and light skin. His hair has an unknown color. He wears dickies, onesies, a mask, a shower curtain cape, and carries a vacuum in one hand and a K-bar in the other, with a Van sneakers. Well, that's fun. These are facts. I agree. Well, how'd you guys like that story? How's it? Okay. So I guess enough with the laughing right now. So I'm kind of interested in this one. I switched the page. So, So this one is State's Motion and Lemonade, Neuropsychological and Psychiatric Evidence. Here comes now the state of Idaho by and through the Latah prosecuting attorney and respectfully moves the court for an order in limine prohibiting defendant from offering testimony regarding neuropsychological evaluation and psychiatric evaluation of the defendant as summarized in the defendant's January 23, 2025 supplemental response to a request for discovery regarding expert witnesses. Specifically, the state objects to the proposed testimony of expert witnesses identified in the defendant's D7 and D13 appended to defendant's supplemental response to request for discovery regarding expert witnesses. In support of this motion, the state respectfully refers the court to Idaho Code 18-207, which provides that mental condition shall not be a defense to any charge of criminal conduct except evidence on issues of any state of mind which is an element of offense. Idaho Code 18-207, 1 and 3. In each of the witness summaries, defendants Exhibit D7 and D13, the defendant specifically states the testimony is not intended to be a mental element defense pursuant to Idaho Code 18-207, but rather this testimony is about state of mind as well as factual defense testimony to anticipated testimony elicit by the state. As such, the proposed testimony falls outside the mental condition evidence allowable under Idaho Code 18-207. Bill, you have no idea what you're talking about right there. I don't think that that's what Bryan is going for. I think what Bryan is going for there is exactly what True Crime with Anna D was saying, that in the state of Idaho, you can't put somebody with a mental illness to death. And so I think Ann Taylor's coming at the angle for getting the death penalty stricken. Not that they're going for an insanity plea. No. I mean, I guess Bill Thompson didn't have a response to that. So, I mean, he had to give a response of some sort, but I guess a wrong response is better than no response. So he can't counter that. He can't counter this argument about the autism. And, like I said, it's for the purposes of striking the death penalty. Just as is, just because it's present. Not for a mental state, not for any type of plea, just because it's present. It's part of the elements of this case, or Bryan in particular. Oh, you didn't? Okay. Oh, wait, I remember. Yeah, you did. Thank you, Anna, for finding that information. Oh, yeah. Thank you for reminding me. What great research. All right, am I sharing? I am sharing the right page. Okay. So here we are at the Idaho.gov website. Title 19, Criminal Procedure, Chapter 25, Judgment. Imposition of death penalty upon, this is very antiquated terminology here, but I do think this falls under autism, upon neurodivergent person prohibited. As used in this section, neurodivergent means specifically sub-average general intellectual functioning that is accompanied by significant limitations in adaptive functioning in at least two of the following skill areas: communication, self-care, home living, social or interpersonal skills, use of community resources, self-direction, functional academic skills, work, leisure, health, and safety. The onset of significant sub-average general intelligence functioning and significant limitations in sub-average functioning must occur before the age of 18 years. Or B, significantly sub-average general intellectual functioning means is intelligent quotient of 70 or below. Number 2, in any case in which the state has provided notice of an intent to seek the death penalty pursuant to Section 18-4004A Idaho Code, and where the defendant intends to claim that he is neurodivergent and call expert witnesses concerning such issues, the defendant shall give notice to the court and the state of such intent at least 90 days in advance of trial, or such other period as justice may require, and shall apply for an order directing that a neurodivergent hearing be conducted. Upon receipt of such application, the court shall promptly conduct a hearing without a jury to determine whether the defendant is neurodivergent, provided, however, that no court shall, over the objection of any party, receive the evidence of any expert witness on the issue of neurodivergence unless such evidence is fully subject to the adversarial process in at least the following particulars. Okay, so, what's number 3? If the court finds by preponderance of the evidence that the defendant is neurodivergent, the death penalty shall not be imposed. The jury shall not be informed of the neurodivergent hearing or the court's findings concerning the defendant's claim of neurodivergence. Number 4, in the event of a conviction of first-degree murder of a person who has been found to be neurodivergent pursuant to subsections 2 and 3 of this section, a special sentencing proceeding shall be held promptly to determine whether the state has proven beyond a reasonable doubt the existence of any of the statutory aggravating circumstances set forth in subsections 19-2515 9A through K Idaho Code. A special sentencing proceeding shall be conducted before a jury unless a jury is waived by the defendant with the consent of the prosecuting attorney. If the defendant's guilt was determined by a jury verdict, the same jury shall hear the special sentencing proceeding. Due to an insufficient number of jurors, the trial court may dismiss that jury and convene a new one of 12 persons plus alternate jurors as the trial court deems necessary pursuant to subsection 19-1904 Idaho Code. If the defendant's guilt was determined by a plea of guilty or by a decision of the trial court sitting without a jury, or if the retrial of the special sentencing proceeding is necessary for any reason, including but not limited to a mistrial in a previous special sentencing proceeding, or as a consequence of a remand from an appellate court, the trial court shall impanel a jury of 12 persons plus alternate jurors as trial court deems necessary pursuant to section 19-1904 Idaho Code unless such jury is waived. If a special sentencing proceeding is conducted before a newly impaneled jury, the state and the defense may present evidence to inform the jury of the nature and circumstances of the murder for which the defendant was convicted. The newly impaneled jury shall be instructed that the defendant has previously been found guilty of first-degree murder, and the jury's purpose is limited to making findings relevant for sentencing. Okay. B. At the special sentencing proceeding, the state and the defendant shall be entitled to present all evidence relevant to the determination of whether or not a statutory aggravating circumstance has been proven beyond a reasonable doubt. Disclosure of evidence to be relied on in the sentencing processing shall be made in accordance with Idaho Criminal Rule 16. Evidence admitted at trial shall be considered and need not be repeated at the sentencing hearing. C. If a unanimous jury or the court of a jury's waived finds the existence of a statutory aggravating circumstance beyond a reasonable doubt, the court shall impose a fixed life sentence. If a unanimous jury or the court, if a jury is waived, does not find the existence of a statutory aggravating circumstance beyond a reasonable doubt, the court shall impose a life sentence with a minimum period of confinement of not less than 10 years, during which period of confinement the defendant shall not be eligible for parole or discharge or credit or reduction of sentence for good conduct, except for merit service. 5. Nothing in this section is intended to alter the application of the rule of evidence or limit or extend the right of any party to assert any claim or defense otherwise available to that party. 6. Any remedy available by post-conviction procedure or habeas corpus shall be pursued according to the procedures and time limits set forth in section 19-2719 Idaho Code and history. I thought I read something different. No, I guess this is what I read earlier. So I guess this is saying that they will have a special sentencing hearing and the death penalty may be stricken. All right, let's see what you guys are saying. What do we think about this? All right. So is everybody just arguing with Jeff? Is that what's going on right now? You guys, don't be swayed. Don't feed into it. Oh, it's a Mad Lib. Is that what I was reading? Wow, those things are from like elementary school. Wow. Okay, so that was earlier. Anna, thank you for sending the statute or whatever this is. So this is the other angle that Ann Taylor is going to come at to strike the death penalty. Let's see if there's another thing. Well, why don't we look at this one? Alternative. State's motion in limine, alternative perpetrator evidence. All right, let's see. Comes now the state of Idaho by and through the Latah County prosecuting attorney and respectfully moves the court in limine for an order prohibiting the defendant from offering alternative perpetrator evidence or argument without first satisfying the court that any such evidence is relevant and admissible pursuant to IRE 401, 402, 403. In support of this motion, the state refers the court and counsel to State v. Meister, where the Idaho Supreme Court addressed the standing for assessing the admissibility of alternative perpetrator evidence. In Meister, the Idaho Supreme Court held the Idaho Rules of Evidence, adopted in 1985, implicitly overruled State versus Larson. The proper analysis is under the same rules of evidence from above, citing the State versus Self. The Idaho Supreme Court noted that the trial court must first consider and determine whether the proffered evidence is relevant under IRE 401. The second step is to determine whether the probative value of the proffered evidence is substantially outweighed by the danger of the unfair prejudice, confusion of the issues, or misleading the jury by considerations of undue delay, waste of time, needless presentation of cumulative evidence. Noting the Larson court was concerned that a defendant will attempt to admit evidence where the sole purpose is to infer that the individual other than the accused committed the crime. The Idaho Supreme Court stated, if the defendant proffers evidence which merely tends to mislead the jury that another person committed the crime, or the evidence is not relevant because it does not tend to make the defendant's involvement more probable or less probable, then it is within the trial court's discretion to find the evidence inadmissible. Mere inferences of another person could have committed the crime will most likely be not relevant, and if relevant, will be subject to the limitations provisions. Okay. So the Idaho, but whatever they're talking about here, I don't know if they found blood DNA evidence at the crime scene that they didn't investigate. So we'll see how that goes, Bill. In this case, during the course of the investigation, literally thousands of tips regarding possible perpetrators were received by law enforcement, with the exception of information regarding the defendant. None of these tips were substantiated. The state submits that any attempt by the defendant to offer or argue an alternative perpetrator theory without evidence specifically connecting person or persons other than the defendant to the homicides would do nothing more than mislead and confuse the jury, and would also result in undue delay, waste of time, would be needlessly present. Did I read this already? Or did he say it twice? Presentation of cumulative evidence and unfair prejudice to the state. Under Idaho Supreme Court ruling in Meister, this should be prohibited. The state respectfully submits that the defendant should be precluded from offering or arguing alternative perpetrator evidence without first meeting the relevance and admissibility thresholds of IRE as analyzed in Meister Court. I don't know. I don't think they should be able to keep blood evidence out or other alternative perpetrators. Like, I would feel like the state lied to me if I'm done at the, the verdict has been read and I'm back out and I'm, with everybody else listening to the news and like finding out what happened in the case, or reading one of these documents and being like, whoa, I was completely lied to by the court or by the state. They didn't tell me the whole story. Anyway, that's just how I feel about that. So let's just take a look. Was it the State v. Meister? See if there was any blood in here, if we can find it. I don't know what happened here. Oh! No, but it's a Meister. Where did that go? Here. Oh, here it goes. Why didn't it copy? Okay, so it looks like in State v. Meister, evidence other than the alternative perpetrators out of court confessions. They had other people confess and they kept that out of court? Oh, that evidence included evidence that human blood stains had been. Let's click on this one. Kathy, you make me laugh. This is one of the most useless and limiting motions I've It does not give a legal standard, no evidence cited. I love it. I don't know why, but that makes me laugh. Okay, so I was curious to see if let's find. Here we go. You guys are on an adventure with me. This is how I do my research. So you're just along for the ride, I guess, this time. So the Supreme Court first addressed evidence other than the alternate perpetrators out of court confession. The evidence included evidence that human blood stains had been discovered on the back seat of Butler's vehicle and on a spare tire in the trunk, but the trunk of Butler's vehicle had been thoroughly washed and cleaned when the body and interior of the vehicle had not. The plant particles matching the plants growing at the victim's gravesite were found on Butler's vehicle, but Butler was not at work the day of the murder and was suspected to have taken place when he returned to work. He had deep scratches on his face, and that Butler had previous sexual relationship with the deceased and had lived with her. Larson also proffered testimony that would establish that the deceased had told a schoolmate that she was pregnant with a child of a married man, but the schoolmate could not remember the married man's name, and no evidence was offered to show that Butler was married. The deceased has told the same schoolmate that she knew someone was going to unalive her, but no offer was made as to whether the deceased had revealed the name of this person. In reviewing the admissibility of the evidence, the Idaho Supreme Court set forth the direct connection doctrine, holding that in order for evidence of an alternate perpetrator to be admissible, there must be proof of a train of facts or circumstances that tend to clearly point out someone besides the accused as the guilty party. What do you guys think? Do we have that in this case? Okay. The Supreme Court concluded that Larson's offer of proof did not create a train of facts or circumstances which clearly point to another perpetrator and instead made nothing more than conjectural inferences. The Supreme Court held that the evidence was inadmissible and did not sufficiently demonstrate that someone other than the defendant committed the crime. Okay, so we're going off of the deceased who said that she was in a relationship with a married man and that she was pregnant. That doesn't seem as solid as somebody else's blood was found in the house. And it's likely that the whoever blood that is from the inner circle of the victims. I would hope that there is a direct connection doctrine. What is that a real thing? Let's see. The direct connection doctrine is a controversial defense strategy. Oh, it's controversial. That requires a defendant to show a direct connection between a third party and a crime. The doctrine is often used when other defenses are not available. Bryan has like 4 or 5 of them right now. How it works. The defendant must show that a third party had the motive, opportunity, and direct connection to the crime. I wonder if that 8-hour delay could possibly work in there. The defendant can use evidence such as reports to the police about the third party's misconduct. The defendant can use evidence that the third party committed similar offenses. Criticism. The direct connection doctrine has been criticized for being out of step with modern evidence codes and the federal rules of evidence. The doctrine has also been criticized for unconstitutionally inferring the defendant's rights to present a complete defense. The doctrine has been criticized for transferring credibility questions from the jury to the judge. Who are we listening to? Oh my gosh, I know you guys know this. Oh, I was just listening to it. Someone suggested that maybe Bryan should request a bench trial because juries nowadays, you never know what they're going to do. And one of the criticisms here for the direct connection doctrine is that it transfers credibility questions from the jury to the judge. Well, if you have a bench trial that takes care of that criticism, I don't know. I'm just putting something out there. I have no idea if a bench trial would be better or not. It's too hard to say. I guess going with the jury, you just have to convince one of those. And hopefully there is someone on the jury that has some sense about trace transfer DNA versus blood evidence. Okay, related concepts. Direct evidence is evidence that directly links a defendant to a crime. This type of evidence includes witness testimony, expert opinions, and other forms of proof. So this website here, also the little snippet says I guess that's where they got it from. It transfers credibility questions from the jury to the judge. Okay, let's make sure that we can look at a law website to make sure that we have that we can confirm it a few times in these law websites to make sure that it's accurate information. So this is going into direct evidence. Okay. This one is going also, talks about the eyewitness testifies. The defendant majorly noted a third party had a motive. Okay, well, normally I would click on all of these and read a little bit, but I think, I can hear feedback. I think this one is going to be good to click on, and it is. Is this a law website? Let's see. The State Bar of Wisconsin, it sure is. All right. Now, the State Bar of Wisconsin, of course, everything is not going to relate to Idaho because, each state has their own rules. However, we can get a general sense of what we were reading earlier to see if we're anywhere near where we can say, okay, we can see it here, we can confirm that that could be right. So many, okay. So in State v. Wilson, a Supreme Court majority 5-2 held Wilson's first-degree intentional homicide conviction and clarified the test for circuit courts to use in determining the admissibility of third-party perpetrator evidence. Wilson was accused and convicted of killing his ex-girlfriend, Ivania Merrick, in 1993, and also attempting to murder Willie Friend, who was with Merrick when she was shot. Witnesses say they saw a gold Lincoln Continental pull up to Merrick's car, parked outside After Hours Club, operated by Friend's brother. Merrick, who was romantically involved with Friend, were sitting in the car. The gunman opened fire on both of them. Only Merrick was killed. At trial, Wilson argued that Friend had lured Merrick to the car outside an after-hours club for the purposes of having her killed by a third-party assassin or assassins and framing Wilson for murder. Wilson sought to introduce the testimony of two women who said they heard Friend previously threaten to kill Merrick by the trial court, but the trial court would not allow it. I'm still thinking that, these are witness testimonies that aren't always accurate versus actual blood evidence. Anyway, defense counsel suggested Friend believed Merrick was pregnant with his child and wanted to avoid paying Merrick child support. The defense also suggests that the third-party assassins fired shots at Friend for show to make it look like Wilson did it. After a 7-day trial, Wilson was convicted of murder, attempted murder, and sentenced to life in prison. The circuit court denied his post-conviction motion relief. Ultimately, an appeals court reversed, concluding Wilson's offer of proof was sufficient to show Friend had motive to kill Merrick. Interesting. The opportunity to do so and a connection to the crime, regardless of whether Wilson's evidence was sufficient to establish Friend's guilt. It wasn't harmless error. the appeals court ruled to exclude testimony from witnesses who saw a friend threaten and slap Merrick 2 weeks before the shooting occurred. The appeals court ruled that Wilson was entitled to a new trial based on error. I wonder if there's any video or any witnesses that are willing to come forward to talk about fights from maybe some of these fraternities. But a Supreme Court majority disagreed, clarifying that proffered evidence must create a legitimate tendency to believe someone other than the defendant committed the crime under State v. Denny. A defendant, the majority noted, must show a third party had a motive and the opportunity to commit the crime, as well as direct connection to it. Did they save any of that blood evidence to start testing now? Because I don't know. We conclude that for the defendant to show a third party had the opportunity to commit a crime by employing a gunman or gunmen to kill the victim, the defendant must provide some evidence that the third party had the realistic ability to engineer a scenario, wrote Justice David Prosser for the 5-justice majority. Here, Wilson failed to show that Friend had the opportunity to kill Merrick directly or indirectly. Consequently, it was not error for the circuit court to exclude Wilson's proffered evidence. Justice Prosser explained. The majority noted overwhelming evidence that Friend was not the shooter, leaving only the possibility that he conspired with a third party to have Merrick killed. The majority, as noted, witness testimony that indicated Friend was in real danger of being killed, and Wilson offered no proof that indicated Friend could have directed Merrick's murder. For instance, Wilson did not show that Friend or any Friend's associates had access to a car that was similar to Wilson's car. That friend called anyone that night, or that Friend or his family owned the type of weapons that were used to carry out the murder. In short, he has not offered any evidence whatsoever indicating that a Friend had the means or access or ability to hire assassins to kill Merrick at a particular place within the relatively short time frame. If this alternative perpetrator is let in, I think in Bryan's case, it's a lot stronger than what this case had. So, concurrence. Justice Annette Ziegler, joined by Chief Patience Rajansat, wrote a 22-page concurrence to clarify that the majority opinion is intended to reaffirm the Denny test. Ooh, that's something else to look up. And that certain passages in the majority opinion should not be misconstrued. For instance, concurring opinion noted a defendant must prove all 3 prongs of the Denny test: motive, opportunity, and connection, despite the majority's suggestion that a strong showing on one prong could lower the threshold on another. Dissent. Judge Shirley Abrahamson, joined by Justice Ann Wash Bradley, wrote a dissenting opinion concluding that appeals court was correct to order a new trial. By excluding the defendant's third-party perpetrator evidence, the circuit court denied the defendant his constitutional right to present a complete defense, she wrote. Abrahamson noted that Wilson was arguing that Friend lured Merrick to a place where she could be murdered at his direction, and the facts showed this opportunity. Thus, the dissenters said it was wrong to exclude the testimony about Friend's threats to Merritt. Willie Friend was the state's primary witness. With the admission of the defendant's third-party perpetrator evidence, the jury may not have considered Willie Friend a credible witness, Justice Abraham said. Okay, so that has some of the elements in this case. Meg P, are new documents out? Well, we def know that there's a 911 call. There is a motion to seal or redact it. There is? Is that set up? Yeah, we're entitled to it. Okay. Aww. Too Fast for Flea's best name says, Kathy Indizone has no idea how well she makes my weekends while working outside and makes the yard work go by faster listening to her. Oh, that's so sweet. I love listening to her too. Oh, there's another one. Am I missing court documents? There's a motion in limine for immediate family members in the courtroom. What? All right, let me refresh this page here. Okay. Maybe, I don't know if mine is refreshing. I don't see any of that. It may be, oh, Meg P, thank you. I completely forgot about that. All right, let's go to the secret. Okay. Ooh, it does say it was updated. Let's see. So, this is what I very. So they do have your statistical analysis, and I'm thinking that from blood DNA evidence, because I can't imagine it would be for Bryan's. Let's see. guys are still here. Ah, that's so big. There we go. Can you guys still hear me? Am I still here? I got booted for a second. Oh, good. Thanks, Meg P. Motion to exclude the bushy eyebrows. There's last from 224. All right, I'm very interested in. You were down here. Oh, I can zoom in a bit. I wonder if that helps. Oh, there's a lot more here than I thought. All right, let's go up to where. So the first one of the new ones, it's a motion, state's motion, eliminate alternative perpetrator evidence. State's motion for neuropsychological psychiatric evidence. State's motion eliminate for the alibi. Admissibility of demonstrative exhibits and memorandum in support states to exceed the page limit. A motion in limine, we all saw this one coming. Investigative genetic genealogy states. Subject document motion to redact. Oh, it is on here, Meg P. There's a motion to redact or seal newly filed record. Motion eliminate 911 call. Ooh, is this the state? Because that's really sketchy if that's the state. Do we know? Yeah, you're probably right, Susan.
The sound of silence.
I'm pressing stuff. Okay. So do we know? Does anybody know? Oh, where was I? It's got to be the state. So they do want to put the 911 call in limine. Immediate family members in the courtroom. Which ones? Was it Bryan's immediate family or the victims? Immediate families in the courtroom. Okay. The next one is improper death penalty comments. Who made the improper death penalty comments? Oh, I see. Okay. Text messages and testimony. Why are they going to put that in? Or is that? This is really weird. AT&T timing advance records. Yeah, was it you make P? They want to put everything in limine. Ooh. Yeah. Definitely Too Fast for Flea's best name. Okay. Let me look again here. Yeah, they want to see They want to put in limine the time in advance records. They want to seal all the exhibits. I'm just like blown away that like all of this is going to be sealed, and the judge is just like, okay, let's seal your whole case because you don't have one. That's a great idea. Self-authentication of records. What is that? Inflammatory evidence. Vague and undisclosed expert testimony. Okay, so I want to know so self-authentication is a legal principle that allows documents to be admitted into evidence without needing additional proof of authenticity. This is because the law presumes that these documents are inherently credible and reliable. Okay, that was Google, so let's see what Cornell Law School has to say. Evidence that is self-authenticating. A seal. Did you guys know, that saying for red tape, you got to get through the red tape, and it just is a government that's like really slow and has all these rules? Well, that's based on a true story. I learned that not too long ago. France. It was the king of France that kept sealing everything in that red wax. Or was it Spain? No, I think it was Spain. It was Spain. Because the Spaniards, they take so long to do everything. Like, I've watched like YouTube videos about Americans living in Spain or wherever. And they're like, the government is so slow here. And like, it's just a way of life where they take really long lunches. They don't work as much. They stay up late with their families. The work-life balance is a lot different. And that's so, people aren't as concerned with like working a lot like Americans. So all that government stuff, takes forever. I know like if you get your passport renewed or whatever, and that takes a really long time to do too. Here, I can't imagine how long that takes. You're probably waiting around for months to get Spain to come around with all the red tape. I can't believe that. Like it's like some king. I forgot what king it was, but yeah, he just kept sealing information in this red wax, and nobody could get that information. Anyway, I thought that was really funny. All right. Yeah, here we go. Order that it be treated as presumably authentic without final certification. Okay, so are they trying to, oops. Am I still here? Yeah. So I had to take a detour to see what self-authentication means. All right. So the state wants to seal documents that should not need authentication. That's a little odd. All right. Motion eliminate. Inflammatory evidence. I don't know what that means. Motion eliminate. Vague and undisclosed expert testimony. The use of the term murder. That is odd. What do you guys think? They want to put the term of murder in limine? How does that even work? Oh! Walking Yantaka, welcome! They're trying to circumvent showing their work or chain of custody. Thank you for putting it so succinct, right to the point, short and sweet, and that's what they're doing. That sounds about right, because it's prejudicial. Trial by ambush. Yeah. But that's the whole case. How can the state want to put the entire case in limine? So if they're putting everything in limine, are they only presenting a questionable STR profile? Like think about it. If they're just knocking all these things out and be like, yeah, just put these in limine, what is going to be left for them to argue at trial? What do we do? Are we singing? Susan B? She's rocking. Okay. Yeah. That's all they want to present is the transfer DNA, and then they don't want the jury to know about the blood evidence, other suspects, Bryan's cell phone that exonerates the exculpatory, or they don't want the jury to hear the 911 call? Or is some of that the defense? I'd really like one of our law tubers to help explain that. Hopefully they will. They need a while to absorb all of this information. So, I saw Toby. Welcome, Toby. Toby, I think you're right. Something odd is going on with the 911 call. Nobody knows. Yeah. Nobody ever wants anybody to hear it. The only thing that would be shared is a blurry non-Alonso photo. Yeah, it's a Ford Focus. The only car that we saw clearly on camera that night belongs to a police officer. Oh, here, Twiz is quoting Fry. We got our guy. We're gonna have it. You're gonna have to trust us. Right? Blurry cilantro. Songs about pain? Where's Diane? We have songs about pain. Okay, did I finish looking at this? No. Witness identification by bushy eyebrows. That is hilarious. Wait, I'm so curious. Who put that in? I'm thinking these ones down here are very organized. So I feel like these are the defense. Up there is really sloppy is the prosecution. We need the U-Haul evidence, right? Okay. So I'm gonna guess, purely guess. All these right here are the states. Limine for IgG, 911 call, immediate family in the courtroom, improper death penalty comments, text messages, AT&T records, motions, self-authenticating records. And then look how beautiful and organized these are. At number 1, number 2, number 3. I bet this is Anne. My guess is the defense wants inflammatory evidence in limine. Makes sense. Vague and undisclosed expert testimony. Definitely. We already had some of that. The use of the word murder. The use of the term psychopath or sociopath. Put Riley Nolan a reference to touch and contact DNA. I think that's the way to go because Anne's got to call it trace or transfer. This touch DNA, I don't think should be allowed to be used in the courtroom because it's too prejudicial. And the type of DNA that could be considered touch DNA, which doesn't even describe the complexities of trace transfer DNA. Whenever the state is trying to explain touch DNA, that may not have been what happened. Because, you know, if you've been watching my channel, trace transfer doesn't need any touching to move. And so this touch DNA, I think, should be banned from all courtrooms. Let's just see. And so, okay, here's one for the defense. Witness identification by bushy eyebrows. So they want that in limine. Yeah, I don't think that describes a lot of people. Unnoticed 404B evidence. That's interesting. What's unnoticed? All right. Including Amazon click activity. Yeah, if that didn't provide any information, there's no need to have that in the courtroom because that confuses a jury, and if there's no fruit, there's no substance there. Okay, improper expert opinion, middleman. Oh my gosh, is middleman the guy from Ortham? Hold on, guys. Yep. Yeah, look. Okay, so guys, the defense wants to put in limine middleman. Middleman is the woman, she's the chief business development officer at Ortham. That's interesting. That I could be wrong, but the defense, I feel like this is the defense. They want to put in limine her entire testimony. Exclude IgG evidence. You know, I have no idea who put these in. But anyway, somebody wants to exclude the Ortham woman, the make and model of the suspect vehicle, conditions as aggravator, this is to request to seal. Oh, motion to redact or seal. Oh, sorry, I was sharing the wrong one. Inconclusive data and statistical analysis. That's DNA. That's definitely DNA. And I think I could be completely wrong, but the state putting this in limine because they don't, it goes along with the alternative perpetrator pattern of facts. So they don't want the information, the statistical and the DNA documentation to be at trial for the other people. Stipulated argument of the parties regarding investigators in the courtroom. That's really odd, too. Okay, nobody is allowed to mention a 2014 cell phone incident. No, wait, sorry. Pending. They're asking for that. Leave to file additional motions challenging the death penalty. So when they ask for leave, is that when they're asking for some more time so that they can submit more motions about challenging the death penalty? No Shannon Gray allowed. Miss Potts! Was Miss Potts here? There she is. Oh my god, Miss Potts. Did you see? Oh my gosh. I think they want to eliminate the other DNA documentation for the other perpetrators. And the 911 call, they want to eliminate. Did you get a chance to look at all that? And welcome, Miss Potts. Oh, I didn't see you. You're driving. Okay, well, I'm sure I'll be watching your live shortly, too. But there's a lot on here that I have questions about. And I don't know when you got here, Miss Potts, but somebody put eliminate the inappropriate, what did they say? Improper expert opinion testimony of Middleman. Middleman is the CFO of Ortho. That's Ortho. So I think that's interesting that they want to put that eliminate. Okay, where was I? Okay, so they're asking for leave to file additional motions challenging the death penalty. And then they're asking to exceed the page limit. And then this one says to preclude the death penalty and adopt other necessary procedures due to the state's numerous disclosure violations. Excuse me, they're asking for sanctions there, I believe. Don't take anything I say seriously because I'm not a law tuber, but I think that's what that means. Okay, see, remember we were reading earlier about I don't want to say the phrase, but the spectrum where the death penalty, like in Idaho, the law is you can't use the death penalty for somebody on the spectrum. And so right here, I do believe the defense filed a motion to strike the death penalty citing autism spectrum disorder. And that is another way Ann Taylor is going after to get the death penalty stricken. So that's new. I didn't even think of that. Okay, and then they have a stipulated motion for that same one. Okay, I got it all. But like I said, I don't know who submitted what. Oh, pulled over, Miss Potts. All right, I'll go back up here. Where does this start? Oh my gosh, dude. Okay. Miss Potts pulled over. All right. Are you in chat now, Miss Potts? So I can briefly show you what's on the secret. Waiting for documents again. Do you think we'll have more documents? All right. Can you see the screen? This Potts. Let me see if I can. Oh, that's pretty good. She's mostly listening. Yeah. Oh no. Present. I got lost. Can't see it. Okay. I think my internet connection. Okay. Oh my god, of course. The second you pull over to look for spots, my internet is not good. Yeah, I'm having issues with this internet. I don't know, guys. That sucks. I'm sorry. The internet doesn't know. All right. So, of course, the first one here, which I think you probably heard about, Ms. Potts, is the motion in limine for the alternative perpetrator evidence. There's a motion in limine for the neuropsychological and psychiatric evidence. Motion in limine for the alibi. Motion in limine for admissibility of demonstrative exhibits and memorandum support. I don't know what that is. Of course, there's a motion in limine for the IgG. There's a motion in limine for the 911 call. And I don't know who would be the state. Oh, my page is back. Oh, Kathy says they haven't released the 4 subpoenas. All right. Okay, so I left a motion. Oh, no, that's not a motion in limine for the 911 call. They want to redact or seal it. Okay, well, hopefully we get a little bit of that 911 call then. Okay, so the motion in limine is immediate family members in courtroom. So I would assume that's the state. Well, the defense would never do that. They would never be like, we don't want the family members in the courtroom. Okay, so there's a subject document to redact and seal and proper death penalty. So text messages and testimony. Motion in limine, AT&T advanced timing records. Motion to redact or seal more exhibits for the motion to eliminate. Document to redact and seal self-authentication records. Motion to eliminate inflammatory evidence. Motion to eliminate testimony, which we heard a lot of that from that secret hearing. Motion to eliminate the use of the word murder. Interesting. Motion to eliminate using the term psychopath or sociopath. Motion to eliminate Riley Nolan and the reference to touch and contact DNA. Motion to eliminate witness identification by bushy eyebrows. Motion to eliminate unnoticed 404B evidence. Motion to eliminate excluding Amazon click activity evidence at trial. Motion to eliminate improper expert opinion testimony. Middleman. Middleman is the CEO of Ortham. So this is Ortham. Somebody put in that they don't want improper expert opinion from middlemen, basically Ortham. Motion to eliminate to exclude the IgG evidence. Motion to eliminate motion to eliminate conditions as aggravator. And then they want to seal and redact exhibit to support motion to eliminate. Excluding IG, motion to redact or seal and disclosed expert testimony, motion to redact and seal witness identification by bushy eyebrows, motion to redact and seal inclusive data and statistical analysis. I think these are some of the DNA profiles, maybe not necessarily the other blood DNA profiles found at the scene. So we have, I don't know, motion to redact or seal inclusive data, motion to redact or seal statistical analysis, motion to redact or seal stipulated agreement of the parties regarding investigators in the courtroom during trial, motion to redact or seal stipulated motion to seal stipulated agreement order. Weird. Motion to redact or seal parties to not mention 2014 cell phone incident during trial. Oh, they have a proposed seal order on the parties' agreement to not mention the 2014 cell phone incident. Motion for leave to file additional motions challenging the death penalty. So I guess that's the defense asking for more time so that they can submit more motions to challenge the death penalty. And I guess they want to exceed a limit. They want more pages. Motion to preclude the death penalty and adopt other necessary procedures due to the state's numerous disclosure violations. They're asking for those sanctions. Motion to strike death penalty, autism spectrum disorder. Motion to redact or seal support of their motion to strike death penalty, autism disorder. And that's going to be under seal. And then I think that was it. Caught up. There's a lot of interesting things in there. He identifies as a furry. Are we talking about Detective Payne? Who's a furry? Wakin Yan Yatanka, I noticed that too. That I think the defense motions are they're not locked like the other ones. Oh, I see. Let me see. So the defenses are all of these that are Adobe icons, right? And then there might be two with locks because they agreed to something. And then all of these ones with locks is the state. And then that could be, I like that. Yeah, so the yellow locks are most likely for the state, and the red Adobe. Hello, IME. Welcome. This is be funny. Yeah, okay. So I'm going to share this tab. I don't think it's working. What are you guys talking about? It's so funny. All right. So that is exciting. There's so many things that dropped. I was like looking on Twitter earlier to see if Bryan Kohberger is trending, but I didn't see him. Yeah, so we learned a lot. We learned about authentication of the record. We learned about Meester. We looked at the State Bar of Wisconsin to see what some of the things that they documented in Wisconsin about the alternative perpetrator. And like you have to meet the Denny bar. Is it Denny doctrine? What did they call it? And that is like, what is it? It's called the Denny test. Motive, opportunity, and connection. So for the third party alternative perpetrator defense. Oh, I'm gone again? Oh no. Oh! Like I clicked on all this stuff like 5 minutes ago. And now it's finally coming up. The Idaho portal is frozen shock phase. Too many people access. Did it go down? The Idaho webpage went down. I'm not surprised that it went down. Oh, you can see me again. That's great. I back? Whew. This internet. Now it says I don't have any internet. Oh my god, am I here? Why? Why isn't there any internet? Huh. Okay. I guess I'm not here. Oh, you can see me. Yeah. Oh wait, I'm here. Oh, am I gone? I can see me now. Uh, oh, did I not get here? I feel like I'm here. Can anybody hear me? Yeah, so then connect to the internet. Oh, you can. Welcome to know. Out of the black hole of Idaho. Yay! Can you see me? Oh, good. I don't know. The internet just was like, nope, I don't want to work anymore. So it says I'm connected now. Yeah, it says I have pretty full strength. Yep. Okay, you can see and check. All right. All right. Thank you for everybody who stayed in here. It's very nice of all of you. Let's see. I'm going to try to share the screen again. So, what do you guys think of this? All of these docs that dropped today. Yeah, it's just, I am just blown away by all the DNA in this case. Yeah, it's going to get crazier and crazier. Yeah, so is Idaho like in their own little bubble and that they don't really realize like how they are? Because they're just coming across as just not connected with reality. So I first got started here because I've been fascinated by trace transfer DNA ever since college. So I've been reading about it, learning about it for so many years. This IgG and SMP, that's newer. I don't know how many years ago it was when like it was so popular, everybody sent all of their spit into Ancestry. And it was like $99 at the time. And I was like, I'm not spending $99 to learn about where I probably know I'm already from. So then I started to learn about what these genealogists do so that you can figure out what part of the world you are on. So I started to learn about the SNPs and the haplogroups, and so I taught myself how to figure out what part of the world I was from. But of course, I didn't get as far as the genealogist would. And of course, at that time, I didn't send in any DNA. So I knew a little bit about the SNPs and the IgG before this case. I was familiar with those. And I was also familiar that there is biomedical data in those. But it really was this case that taught me more about the IgG SMP process. And what I found is that the SMP it's closely related in the criminal justice world to the degraded DNA. And I think we heard Gabriela Vargas, and I think I've watched, videos of the people from Othram, and I think both of them say the DNA they work with is degraded. And Cece Moore, I think she says that the reason why law enforcement sends us this DNA is because it's degraded. And when DNA is degraded and it needs the SMP IgG process, to me, that usually means it is trace transfer DNA. And so for me, the trace transfer DNA is uniquely connected and intertwined with the SMP IgG process. They are two distinct, separate things, but they also kind of are mutual in a way. And I don't really know how to explain that, but they are very close. And so it's really difficult to separate those two at times. Unless when you're a consumer, of course it's different. You're not sending in degraded DNA. They obviously have a fresh, full sample from whoever is sending in their saliva for that. But in law enforcement world, they're doing what you call the identity, the questions that science has surpassed. Oh, your DNA was found at a crime scene, so you probably did it. That's just not how it is anymore. And so they blow up these tiny skin cells, and usually because it's degraded or because it's partial, it's not a complete profile. We will never actually know what those missing pieces are. There's theories and statistical analysis and software to help try to fill in those blanks, but we will never truly know. And so I think that's why experts are always like, well, I can't rule it out, not excluded, because they will never know for sure. They can have a pretty good idea depending on the factors that go into it. Welcome, Typically Unique. Welcome. Hello, Miss Potts. Welcome back. Wait a minute. Twiz, what are we doing? What is this? I don't know. I think that needs to be the thumbnail. What is going on? Welcome back, Miss Potts. So if they only had this single source male DNA on the sheet, why are they heavily discussing STR testing of this sample between ISP and ortho? Oh, welcome back, Amethyst. Great. I'm glad you're back, Miss Potts. I'm glad everybody's back here. I had some technical issues, which I think I have finally fixed. So Amethyst says if they cheated after the buccal swab and sent it in as him, the FBI would be so guilty, and we know they do that. Yeah. So I know that Hitler, I think he tried to ask that same question, right? He was trying to ask, you don't think that they entered Bryan Kohberger's own DNA and it matched to his DNA? That could have been what happened. And it depends on, like if it's like an exact match, I'm pretty sure that means they did it. It should all be a little different. It should all have variables. And I want to get back to what, oh my gosh, no. Daniel is sadly misinformed. Ann Taylor's using that as an argument to strike the death penalty, not insanity. All right, I want to get back to what Miss Potts said. Yeah, so why did they overlook blood DNA samples? They were so honed in on this mixed profile that they couldn't get information out of it at first because they don't have the tools to do it. So that's why they went to Othram and said, pull out whatever you can from this. That's basically what they did, because at that hearing they were talking about bootstrapping. That's basically, you're filling in the blanks. And I know they have theories and statistical software to help you fill in the blanks, but still, they made an SMP profile, and then it also sounded like the FBI made their own from scratch, right? And so the reason why they did that YSTR differential is because, like I said, they made something out of nothing. And like they're trying to hide it. Like, I feel like since we're all kind of learning together about the trace transfer DNA process and how, they basically make something out of something that's broken. which is the degraded DNA. I think we're all kind of on the same page and we're all learning this together, that we kind of figured out, oh, okay, you want to steal everything because you don't want the public to know law enforcement investigation techniques. Well, we kind of figured it out. You're not doing it right. Right? If ISP has and one NSP, in theory, could the FBI have plugged their own SMP to GenMatch to get their match on the family tree? Yeah. Yeah, there's no telling what they did because there's no paper trail. So when there's no paper trail, I feel like that means it's because you don't want people to see your paper. So they probably did do something like that. But that's just my opinion. Filling in should not be allowed. I agree, Twiz. They're filling in something that's broken and can never be fixed. We'll never know what those missing pieces will be. But, they can use all of their statistical analysis they want, but you'll still never know, even if you think you have a pretty good idea. So there were 2 SNPs created. One at Ortham and one at the FBI. Yeah, that's what it sounds like anyway. Yeah, Tiz, you've been telling me this for a while. You know a lot about this SMP procedure. Oh, wait, no. Yeah. It's actually pretty interesting. Read what it said, but it's like filling in DNA shared by everyone. They should fit in unique markers, I would hope. Yeah, there's a lot of things that we share. Exactly. And welcome, Christopher Dorner. Christopher Dorner says, filling in DNA is completing the sequence to create a full identified DNA sample of someone. Essentially, you can fill in a sequence to match anyone you want with a partial sample. Yes. Yes, that's a great way to put it. I agree, David Bird. If the process was so complex, it requires full disclosure and chain of custody. Yep. Well, typically unique. This is great. You said filling in generic stuff gets you nowhere, though, right? Yeah, because you would think. And then they have these so-called experts come in and they want to tell the jury all about the missing pieces of the DNA profile. So it's kind of odd, right? Because you're building something that doesn't really go anywhere, but then you're pointing it in a direction that you want it to go, and then the experts come in and they try to support that. It's a very odd process, and I think it's very prejudicial, and I don't know if DNA should be used at all. Like, I don't know why they can't go back to regular investigation. Especially with the trace transfer. Like, I don't know if they should stop using saliva, blood, sweat, and semen. I guess if it's at the scene and it doesn't have a legitimate explanation, okay, maybe then we could make an exception that DNA is allowed to be used. But otherwise, if it doesn't have those compelling factors, I don't think it should be used at all. I think it should be used to identify missing persons and exonerations, but not be used for conviction. Because conviction is a whole nother thing. Yeah, yeah, amethyst. That's why it's used for cold forensic cases and can take years. Right. And I think it's easier because the person that you're or the profile you're building for someone who's on a cold case, the end result is that you're finding someone who is deceased. So most of the time, and so then that kind of narrows the scope to people who are missing, or they're finding out an identity, but they don't know where the identity goes. But the end result is this person is not present, which I think narrows the scope dramatically, because then you're looking at a population of people who are not present versus as many people as we have live-bodied in the world. So when you get to the end result, it's kind of obvious you're the person that you're building a profile for isn't here anymore. Okay, let's see. Without showing their work, they simply cannot quote the high match odds they did. I would agree. And I know that we were hearing Riley Nolan say that they have to put a statistic with it. I think it needs a lot more than just a statistic. Yeah, and they shouldn't be able to use a statistic if they can't show step by step what they did, and it's signed in and out and dated for everything that happened to it. This is actually a good thing for everyone if they used IgG and failed this bad. I agree. This is a great case to learn about what not to do with IgG. I mean, this case, I think somebody said they're already learning about it in schools. And I'm sure this case is going to grow even more. And we'll learn more about it. Okay. Miss Pop says, I am wondering if I have one SMP and you have one SMP. Can I put one in and label it as SC? And then you put in your SMP as a forensic kit, or will I get a hit? Sounds like you would. Amethyst New Word says, DNA that's a whole sample like ape is acceptable if you have a full seminal sample. They figure that out. Yeah. Yeah, that kind of stuff. This spot says, what if I create a GenMatch profile labeled SC using one SNP, and then the next day you put in your SNP in and we match? That sounds like that Kohberger case where they did some funny stuff with uploading SNPs to get matches. This case is changing the law. Oh, at the Supreme Court level. Oh, yeah. So hopefully that we get some clear answers from them, because we're not getting clear answers from the circuit courts. Circuit courts, they're running around like it's a clown show. Like, at least JJ, he did try to understand, and I think he was getting there, but Hibbler doesn't want to understand, like, at all. Right, David Bird. Hibbler is the obstacle, as he is prepared to accept the BS at face value. I am so disappointed in Hibbler. I had high hopes, and I wanted to, like, support him and be like, well, this is the kind of judge he is. He's very smart. He's very efficient. He knows the law, and in that kind of sense, yeah, he could be strict, but maybe that kind of thing can just be neutrally fair. But as we learned, that is not him at all. Like it's highly disappointing. It's like Hitler. I have high hopes for you. Hitler followed the law. That's it. He did, but what about all that stuff that he filled in and he didn't really like? He said that the DM saw the defendant. Nobody knows that. PC is stupidity low standard. All right. Christopher Dorner. If they cannot show how they completed the alleged partial DNA sample they claim they had, it should not even be discussed or allowed to be used in a courtroom. It's wild they just said it matched. I agree. And if you look at some of the documents or studies that are coming out of Australia or Europe, they're having these conversations. They are adding, you can identify the DNA. That's fine. And that could be important, but you have to ask the how and the when questions in addition to that, because of the nature of the partial DNA profiles, of the nature of the trace transfer profiles, because they are concerned with wrongful convictions and they realize that this DNA, these types of DNA are very problematic. So they are aware, but it's just America is like a third world country and they're just unwilling to just say, hey, we have a problem here. We have a huge, like, human level problem that this type of DNA is causing. And it's causing people to lose their life and liberty and be wrongfully convicted for something our legislators can easily get together and just put in some checks. Stephen Mercer, he's one that helped implement laws in Maryland that are sort of looking at that. They have stricter regulations, and I think they have 13 bodies that have to look at when you use the IgG stuff. There's 13 bodies. I guess they come in, they oversee it, they keep that information, and so that they can look back on it after it's already finished. And so there's a lot of eyes on there. And I can't remember if there's a judge that's kind of involved in every step of the way, that they are involved in like what's happening, and that there's lots of documentation that has to go along with it. So hopefully more states start adopting what Maryland and DC have already done, because of what Stephen Hitler was able to tell us that he helped with. But yeah, the rest of the states, they need to, there's a crisis. There's a humanity crisis going on with this. Amethyst says, in Australia and the UK, transfer DNA are not allowed in court. Yep, because they realize how dangerous it is. Yep. And the army, right? The military court, martial, maritime, what is yeah, just military court. They don't use it either. Phone call, Twiz. There's a call on line 3. Danity Kane, you're back. Welcome. If an officer puts in the DNA profile, does he lie and say his name is Bryan Kohberger in the public database? I think that's what the defense has been hinting at. That's what happened. So, yeah. Military doesn't allow it either. Right. Echoes of clarity. Welcome. Oh, they unsubbed you. How did that happen? Oh, you have notifications on? Thank you for that. Okay. Yeah. Yeah, it's very sad that Hitler has a 1990s style education when it comes to DNA. Well, I'm hoping that that's not true. I hope that he was just saying these things for argument's sake, but it didn't really sound like that. So disappointing. Because he came across as a smart guy. He came across as a guy who would know his stuff. And then he just kind of fumbles it all. It's actually kind of embarrassing for him. And I'm not just saying about the public opinion of him, because he probably doesn't care about that. But what about with his colleagues or like other judges who are just like, wow, this guy doesn't know what he's talking about. David Bird says, AT should get officials from the military and non-touch DNA states to explain why they don't recognize transfer. Exactly. Absolutely. Echoes of Clary says, I mean, if he's on the spectrum, that is why people may think he's weird. Right. And I think people have they sensed it. I think people sensed it since the beginning. They knew. But even if they didn't sense that he was on the spectrum, people definitely sensed that he may be a little weird, OCD, an introvert. They were connecting with something. They what Miss Pot says. For almost 3 years, they told us it was only single-source male DNA on the show. I know, and I was saying this 2 years ago. That you can't there's mixtures and you it's called deconvolution, where you pull out other profiles. And so when you pull out profiles from a mixture, you can either get a single source or you get other mini mixtures. And sometimes in the mini mixtures you might be able to pull out another one, but that I don't think that's as common as pulling out a single source from a mixture. And when the mixture, if they can tell it's more than 4, if it's 4 or 5 people mixed, I was reading things that they like to stay away from that is something that they don't really like getting into, because that gets really messy. I would agree with that. And I would also argue it's even messy when you have a mixture of 2 people, because I keep using the alphabet soup example, where you put your spoon in the mixture, the soup, and you get out all these letters. You can spell whatever you want with those letters. Same thing with the mixed DNA profiles. You can pull out whatever kind of profile you can make with whatever is given to you, or whatever is present. So if we just keep thinking that mixtures are alphabet soup, I don't think that they should be relevant at all. With the exception of the SAs that you were talking about, Ms. Potts, maybe. But even when we have those types of situations, the chain of custody needs to be very clear. Single source doesn't mean what we think it means. Apparently they say it's single source after the unmixing. Yes, they can say it after the unmixing, or if it was just originally single source. But I've known for 2 years that it was a mixture. It was pulled out of a mixture because more likely than not, it was mixed with a victim's DNA. I mean, that is just, I don't know. I don't want to say common sense, but I want to say that that was highly likely. And I think a lot of people realize that, yeah, there's definitely DNA profiles that can be mixed with the victims. And so, yeah, when they take it out, they definitely say it's single source. And I think that's why the state said it. They had to announce to the world, because they have the most unreliable type of DNA that you can have. And how long did it take for somebody, I think it was the defense who first used the words touch or transfer DNA. The state was not going to tell anybody that was the DNA they had until they had to. because they know it's, they're trying to write it. What will rat them out? A whistleblower? I think a whistleblower, and that I think like to be like a responsible citizen is to know this kind of stuff, so that because obviously the court system isn't doing anything about it. So what is that called? Civic duties, where it's our duty to be on a jury. It's our duty to pay taxes. Whatever those things are that make you a good citizen. I think another one is understanding this DNA, because the courts certainly don't, and they're certainly not going to tell a jury about this stuff. And so if I was ever on a jury, I would like to know about this DNA stuff, because I do not want to be responsible for a wrongful conviction. That would just be terrible. And I don't want to be a genetic witness on one of these ancestry websites for the same reason. I don't want them to use my DNA to convict someone who didn't do it. Like, that would just be absolutely terrible. And I know that I heard Megyn Kelly say, oh, well, they just don't want their relatives to get in trouble. No, it's a little bit more complex than that. Okay, Megyn? Out and out discrimination of the mentally challenged. Yeah, because if this is their fault, guys, so sad. And this is not the only time they've done it. I feel like they have used the media for so long. And so maybe this is one of those things that we can notice. If the media is making a huge deal out of a case, the law enforcement doesn't have a case. And so they're trying to sway the public. For me, that is one of the indicators. Is it a rule that is every time? No. But it could be highly likely that if they're trying to coerce us or sway us to feel certain things about a case, my red flags start going, okay, why are they trying to push this narrative? And I do think it's related to how strong law enforcement cases are. Ms. Potts says, it's interesting, all the talk at the lab for YSTR. I think you're onto something there, Ms. Potts. Echoes of Clarity says, I do not think people understand how scared this man probably is, and he acts like my ex-nephew who has Asperger's. They are blunt, but you cannot tell their emotion. Yeah. Danny Kane! That would be a good thing to look up and have documentation to send a letter if the military isn't using transfer DNA in their way. Danny Kane, you just made me think. Podcast with Annie Peterson. She, I don't know if it was yesterday or today, she put up an excellent video and she gave us information and websites to go to if we want to write a letter to our congressman to tell them this stuff. And she gave some names. She kind of taught you how to do it. I mean, I think we would have to do a little bit more digging if you wanted to do it for your own state. But I think it's just great information that she provided, and that's the exact kind of thing we could write about. It's, the military isn't using it. Why are we still using it? It increases wrongful convictions like tenfold or even more so. Juries don't quite understand DNA yet. DNA is extremely prejudicial. This case, there really isn't a case, but the state is still going forward. Like any of those things that we all have been throwing around for 3 years now. I think we've all kind of come to the same consensus, and we all have been saying similar things about this case. So check out her video for the great information she provided. Could be exculpatory. They should investigate all samples, especially mixed at a knife crime. Yep. The blood DNA sample should have been priority. All they needed was a swab from his car door handle and use that and say it was there. Yeah, so I hear these news outlets now say, well, it's really bad evidence. It's really compelling evidence that he was sorting trash and he put his trash in his neighbor's trash and he was wearing gloves. I was talking to some guy on Twitter and I was like, so they could have got his DNA when he in Washington. There's plenty of time, plenty of opportunities for them to get his DNA. So having a story like that, yeah, okay, it's intriguing, but it's probably false and it's a big deal out of nothing. Yeah, they could have just gone to his apartment, gone to his office. They could have gotten his DNA. They didn't have to go. They didn't have to go as far as say as he was doing the dishes when he had gloves on. And he put out the trash, helping his mother do dishes and take out the trash, and maybe sorting some green leafy substance, but still helping his mother. They're making that so nefarious when it doesn't have to be. Exactly. They have gotten away with this in so many cases. Yeah, and hopefully we start seeing these red flags, and then we'll start to know what kind of cases the law enforcement actually has. Well, we can gauge anyway. There's been so many lies from law enforcement in this case, it is insane. Yeah, and you bring up a great point here, because I know that there's this workplace complacency when it comes to actors in the court, whether it's a prosecutor, a defense attorney, a judge, anybody. They do this every day. I've heard them say it's, you have a compelling story for what happened in the case from the prosecution side, or you are the defense and you claim police corruption. And then you're playing with these two opposing sides, and that's just your case. But no, there are actually times when law enforcement is actually corrupt. They're actually, so I know that they got there in this groove or habit or what have you, and that's just what they do, because they'll never know, I guess, if somebody is innocent or not. However, I think this case is the exception to all of the rules, that there are times when it's not just those two opposite stories, having it out in the courtroom, that there are times, when it's clear the defendant probably did it. And there are times where it's clear law enforcement did something wrong. So even though it's just it's interesting to see, what kind of arguments and what work and what doesn't, but in some cases, this is very real. So, a cause of clarity. I think the motion in limine for the autism spectrum is twofold, or even more so. Ann Taylor, I think, is using it as an argument to strike the death penalty, because I think in Idaho there might be some limitations on the death penalty in people with mental disorders, I guess kind of like autism. But at the same time, that's probably something that the jury may not need to know, because a lot of times, I mean, these are health records. I mean, especially a doctor diagnosed him. So it's very unusual for health records to be admissible in criminal court because of HIPAA, and sometimes it's not relevant to the case. But in this case, it is relevant because it could be an argument to strike the death penalty, and it's not meant like that. That's the argument. And so I think what happens is, not saying that you clearly understand the mental disorders, but I was hearing that somebody was trying to say that he's going for the insanity plea. No, that is such low-level thinking that mental disorders automatically equal you're going for an insanity plea. No, it's much more complex than that. You know, it's also like if you are facing murder charges and you actually have cancer and you have a doctor who's working with you and treating you, that is not relevant to the case. I mean, I guess it could be relevant if, depending on what the pattern of facts are, but usually stuff like that is private. It's not related to the case. And this probably wouldn't be related to the case if the death penalty was not on the table. That's my take on it. But thank you for that, Echoes of Clarity, because that is such a great comment. The sad thing is, if Bryan was never tested for autism, imagine dealing with it by yourself at a jail cell. Whew, that's a lot, yeah. Perhaps Anne has stats that show people with Asperger's rarely commit violent crimes. Yeah, I'm sure that goes into it. And also, I was reading, Anna D gave me the website where it said that people with spectrum disorders, that they can have a special sentencing jury, because you know how there's like the criminal part of the trial, and then they have like the little mitigation and sentencing phase afterward, that there can be a special sentencing phase for people with these neurodivergent conditions. And so Anne can definitely, in her argument, bring up statistics like this, that Asperger's rarely commits violent crimes, or like whatever statistics there are out there, in addition to taking the death penalty off the table and getting that special sentencing jury as well. Oh, thank you, Miss Potts, for putting podcast with Peterson, Annie Peterson's YouTube there. They could have asked him to volunteer a sample and got a word. Oh, right, Miss Potts? I feel like he was very sympathetic to law enforcement because he had to work closely with them or learn a lot about them. I feel like if they would have asked, he might have just been like, okay, here you go. Danny Kane says, Audrey, I feel the reason they use transfer DNA is because it is ambiguous and hard to argue. Very true. If their plan was to frame someone, what better evidence could they use? Oh my gosh, it's the best evidence to use if you're going to frame someone. It's the best. Amethyst says ISP wanted to bolster their grant because they only solved the tour's cold case. That's it. They were trying to get more grant money. Oh yeah, I'm sure that plays into it. And she touched on that in her declaration where she put in there where ISP is like, yeah, they have a partnership with those grants with was it Ortham or some type of different DNA lab. David Bird says any conviction based on transfer DNA is unsafe. Yeah, if unsupported materially. Yeah, so I think that when it comes to trace transfer DNA, the lack of linking evidence should be exculpatory. And I know, LawTube is going to be like, well, you can't argue for something that didn't happen or something that doesn't exist. I think, yeah, that's how they're taught to argue. But because of this science, because of this new technology with the trace transfer DNA, I think that argument needs to change a little bit. And I don't know if it's like the human rights groups, the Innocent Project, our legislators, but I think that is a huge component when it comes to trace transfer DNA, when there isn't a linking. Like in this case, there's no DNA in the car. The cell phone apparently was somewhere else. There's no linking evidence to this trace transfer DNA, and that should be exculpatory. State actors. Yep. Actors. The fact that the FBI does not have to show their work, they could have obtained a partial sample of DNA a million ways and said it was off any object found at the scene. Absolutely insane not to show your work. Yeah, 100%, all the way. Oh yeah, that's it. Assisted unaliving is illegal in the U.S. Yeah, when I was in college, that was a new topic and debate. It's like kind of split down the middle about how people feel about that. Typically Unique says, I don't think BK would qualify for that. The question will be, does he know right from wrong, in my experience and opinion? I'm sure that goes into it because there's a criteria, because like whenever you're reading those law, let me see if I can bring it up. Can you see this? It's really small. Because I can't zoom in. Anyway, so that's a great thing you said, typically unique, because it says here, this is the idaho.gov website, and this is for imposition of death penalty upon, I want to put in the word neurodivergent because I don't really want to say this word. I know it's an antiquated word because these laws can sometimes be written, in a very old way. Person is prohibited. And it's this right here that is, I'm guessing, is Anne's argument. But you're right, typically unique. There are several things you have to meet. Like sub-average general intellectual functioning that is accompanied by significant limitations in adaptive functioning in at least two of the following skill areas: communication, self-care, home living, social, or interpreting skills, use of community resources, self-direction, functional academic skills, work, leisure, health, and safety. The onset of significant sub-average general intelligence functioning and significant limitations in adaptive functioning must occur before the age of 18. As used in this section, significantly sub-average general intellectual functioning means an intelligent quotient of 70 or below. Okay, so as used in this section, number 1. So these are the two factors of number 1. And so as in this section, number 2, in any case in which the state has provided notice of intent to seek the death penalty pursuant to section 18-4004A Idaho Code, and where the defendant intends to claim that he is neurodivergent and call expert witnesses concerning such issue, the defendant shall give notice to the court and the state of such intention at least 90 days in advance of trial, or such other period as justice may require, and shall apply for an order directing that a neurodivergent hearing be conducted. Upon receipt of such application, the court shall promptly conduct a hearing without a jury to determine whether the defendant is neurodivergent, provided, however, that no court shall, over the objection of any party, receive the evidence of any expert witness on the issue of neurodivergent unless such evidence is fully subject to the adversarial process in at least the following particulars. So the first part is the imposition of death penalty upon neurodivergent person prohibited, and it gives you 1 and 2. Okay, so if you're going to go with the argument number 1, then you have to meet at least 2 of the following. But if you're going to go with number 2, you are going to, everything I just read here, but then there are some subsections to the other route you can go. And this says, A, if the defendant fails to provide notice as required in this subsection, an expert witness shall not be permitted to testify until such time as the state has a complete opportunity to consider the substance of such testimony and prepare for rebuttal through such opposing experts as the state may choose. B, a party who expects to call an expert witness to testify on the issue of mental divergence shall, on a schedule be set by the court, furnish to opposing parties a written synopsis of the findings of such expert or a copy of a written report. The court may authorize the taking of depositions to inquire further into the substance of such synopsis or report. C, raising the issue of neurodivergence shall constitute a waiver of any privilege that might otherwise be interposed to bar the production of evidence on the subject, and upon request, the court shall order that the state's expert shall have access to the defendant in such cases for the purpose of having its own experts conduct an examination in preparation for any legal proceeding at which the defendant's neurodivergence may be an issue. And I'm wondering if this was the medical records, or at least one of the medical records that they were throwing around. D, The court is authorized to appoint at least one expert at the public expense upon a showing of an indigent defendant that there is a need to inquire into questions of the defendant's neurodivergence. Maybe I should just say mental health. I don't know. The defendant shall pay the cost of examination if he is financially able. The determination of ability to pay must be in accordance with Chapter 8, Title 19, Idaho Code. The report of the examination shall be filed in the triplicate with the clerk of the court, who shall cause copies to be delivered to the prosecuting attorney and to counsel for the defendant. E. If the examination cannot be conducted by reasons of the unwillingness of the defendant to cooperate with either a court-appointed examiner or with any state expert, the examiner or expert shall so advise the court in writing and include, if possible, an opinion as to whether such unwillingness of the defendant was the result of mental illness. The court may consider the defendant's lack of cooperation for its effort or credibility of the defendant's, I just like neurodivergent claim. 3. Okay, so imposition of death penalty upon neurodivergent person prohibited in these instances. You have 1, 2, and now we've gone to number 3. If the court finds by a preponderance of the evidence that the defendant is neurodivergent, the death penalty shall not be imposed. The jury shall not be informed of the neurodivergent hearing or the court's findings concerning the defendant's claim of neurodivergence. 4. In the event of the conviction of first-degree murder of a person who has been found neurodivergent pursuant to subsection 2 and 3 of this section, a special sentencing proceeding a special sentencing proceeding shall be held promptly to determine whether the state has proven beyond a reasonable doubt the existence of any statutory aggravating circumstances set forth in these subsections A through K. So what I'm thinking is Bryan may not fit some of these things, especially up here with 1. I don't know if he fits any of that. I don't know. I'm not a doctor. We'd have to hear from his doctor. But what this also could do, I mean, Hitler could just say, no, that's not the right fit for what this is talking about here. But it can also affect the mitigation, the sentencing phase. I think that even if like a jury does convict with the death penalty, the judge at the sentencing phase has a little bit of leeway. They may be, sympathetic and may just say you can have life, or that's the trial where your attorney is trying to give all the information they can to sway the judge to say, hey, maybe you should lessen the sentence a little bit. That's part of the process. So even if Bryan doesn't fit all this, Ann Taylor is going to make an argument about it so she can possibly strike the death penalty. And if Hitler says no, she can also use it again with the judge at the sentencing phase to ask them for some lenience. That judge could say no too, but I think she's working this angle. Whether it's successful, I don't know. So where were we? We were at number 3. If the court finds a preponderance of the evidence that the defendant is neurodivergent, the death penalty shall not be imposed. The jury shall not be informed of the neurodivergent hearing on the court's findings concerning the defendant's claim neurodivergence. 4. In the event of a conviction of first-degree murder of a person who has been found neurodivergent pursuant to subsections 2 and 3 of this section, a special sentencing proceeding shall be held promptly to determine whether the state has proven beyond a reasonable doubt the existence of any statutory circumstances set forth in the subsections A through K. So even if Bryan doesn't qualify for this special sentencing proceeding, he still has that sentencing phase wherein can ask to be lenient. These are two different things here. This one is the special sentencing proceeding is for this, and the regular sentencing, you can also ask for leniency, but these are two separate things here. So, A, the special sentencing procedure, the special proceeding shall be conducted before a jury unless a jury is waived by the defendant with the consent of the prosecuting attorney. If the defendant's guilt was determined by a jury verdict, the same jury shall hear the special sentencing proceeding, provided, however, that if it isn't impractical to reconvene the same jury to hear the special sentencing proceeding due to an insufficient number of jurors, the trial court may dismiss that jury and convene a new jury of 12 persons plus alternative jurors as the trial court deems necessary, pursuant to Section 19-1904 Idaho Code. If the defendant's guilt was determined by a plea of guilty or by decision of the trial court sitting without a jury, or if a retrial of the special sentencing proceeding is necessary for any reason, including but not limited to a mistrial in the previous special sentencing procedure, or as a consequence of a remand from an appellate court, the trial court shall impanel a jury of 12 persons plus alternate jurors as the trial court deems necessary pursuant to Section 19-1904 Idaho Code, unless such jury is waived. If a special sentencing proceeding is conducted before a newly impaneled jury, the state and the defense may present evidence to inform the jury of the nature of the circumstances of the murder for which the defendant was convicted. The newly impaneled jury shall be instructed that the defendant has previously been found guilty of first-degree murder and that the jury's purpose is limited to making findings relevant for sentencing. B. At the special sentencing proceeding, the state and the defendant shall be entitled to present all evidence related to the determination of whether or not a statutory aggravating circumstances has been proven beyond a reasonable doubt. Disclosure of evidence to be relied on in the sentencing proceeding shall be made in accordance with Idaho Criminal Rule 16. Evidence admitted at trial shall be considered and need not be repeated at the sentencing hearing. If a unanimous jury or the court, if a jury is waived, finds the existence of a statutory aggravating circumstances beyond a reasonable doubt, the court shall impose a fixed life sentence. If a unanimous jury or the court, if a jury is waived, does not find the existence of a statutory aggravating circumstance beyond a reasonable doubt, the court shall impose a life sentence with a minimum period of confinement of not less than 10 years, during which period of confinement the defendant shall not be eligible for parole or discharge or credit or reduction of sentence for good conduct, except for meritorious service. 5. Nothing in this section is intended to alter the application of any rule of evidence or limit or extend the right of any party to assert claim or defense otherwise available to that party. Number 6, any remedy available by post-conviction procedure or habeas corpus shall be pursued in accordance to the procedures and time limits set forth in Section 19-2719 Idaho Code. So even though he may not fit this, Ann Taylor is certainly going to argue this to strike the death penalty, and she'll also get it on record for the sentencing phase. And who knows if it'll work there either, but I think this is, what's happening. But yeah, great comic, typically unique, and you might be right about that after reading that. Heather, welcome. Oh, look at all the hearts. Welcome, Heather. Yeah. So evidence and other DNA possible suspects. It makes no sense they would hold this transferred DNA in such high regard. And then Heather says, y'all, they want to hide the 911 call. Facts. The timing data. Wait, P, that's a great question. Yeah, who? I don't know what side is limiting family in the courtroom, or which family, or all family. Oh, I didn't think of that, Heather. That is a red flag. If they want to hide the text messages between the quote-unquote survivors, witnesses, oh, God, that should signal to Hitler. But I don't know about him. I had high hopes. Oh, hello, Kane. Welcome. No, when I read that thing, I just inserted neurodivergent, but that's probably not what it is. I just didn't want to say that phrase. I don't like it. Okay, I caught up. So I'm caught up in chat. Heather winning out there. Heather, how did you find that Mad Lib? What was that? And then Heather, there's a dollhouse. Why is there a Mad Lib and a dollhouse? They kind of match. They kind of go together. Heather always wins. I know that. Aww. Yeah, thank you all for sticking with me. I know I had some internet problems earlier, and if you're on replay crew and you made it this far, thank you. Wait, what? No. You made it from an actual Barbie website. That is like the most awesome thing I've heard today. Thank you for that. Wow, apparently they have new and amazing things on the Barbie website. I love it. You just like you brought the laughter like when everybody needed it, because like all of these docs that dropped are so serious. Oh, you coming in with Barbie? That's a real website. Yeah, that is so awesome. It was amazing. Yeah, I hope it goes around the world. It's great. And Heather, did you make the Madlet? You you went through the process and it became your song? But is there a song on the second page? Aw, thank you, Miss Potts. Love you too. Oh, so Heather just came with the false narrative, giving it right back. I mean, that's just how it's done. Aw, King is singing to Fitzy. Yeah. Ooh, is Skipper paid? There's cheap fry. Now I'm thinking of Gilligan's Island. Why? Why does Skipper make me think of Gilligan's Island? Yeah. Oh, let me show you. If you were in here earlier, you saw this, but here we go. Can you see this here? Oh, I was presenting. Here we go. All right, am I back up? I'm back up. Right here. Motion in limine number 10. Improper expert opinion testimony. Middleman. That's ortho. Interesting. I didn't know. Since the state said they weren't going to use the IgG, I didn't know if Ortham would testify, but apparently maybe it was an option, and now there's a motion in limine to exclude Ortham's testimony. The improper expert opinion testimony. Well, that's just so many reasons for that. For one, there's no chain of custody, and I think they confirmed something over the phone. Was it Matthew Gamete, whatever his name is? I think he said that there was something that Ortham confirmed over the phone, and at the time, they weren't accredited, and apparently, I don't know. I kind of would like to learn more about that, but probably won't. I'm so interested to see what Hippler does. Do you think Hippler will give a brief explanation of why he would, if he's going to reject some of these motion in limines, if he'll give an explanation, or he'll just be like, no. Wow, I can't believe it got so late. I am really cold too. This has been really fun. It's been a really long time since I've gone live. I will have some more free time now to go live. So, thank you guys so much for being here. You guys are so great. Let's see. I'll show you the other one I find very interesting. Here we go. Motion eliminate number 5 and 14. Inconclusive data and statistical analysis. Wait, is there a motion eliminate for that, or they want to redact or seal it? Let's go back up here. Motion to redact or seal. Oh, so are we not going to... Anyway, I think that this inconclusive data and the statistical analysis might be from the other DNA samples found at the scene. I know. I mean, I think people's brains are melting now with these stuff. And then once all the responses to these, our brains are going to melt some more. Oh, Quality Arnold, welcome. You're not late. We're still here. Let's see. We've gone over the secret, what do you call it? The secret docket. We've gone over the Idaho criminal procedure for imposition of death penalty upon divergent. Wait. Oh. 10 times. Yeah. Thank you everybody for being here. Thank you for the replay crew if you made it this far. I think okay, fun. Okay. So I thought my internet went out. But anyway, if my internet's gonna go out, I'm just, that's fine, because I'm gonna pack it up now. I need a box of popsicles. All right, everybody. Good night, and thank you for being here. It's been so much fun. Bye.